earlier this week, the Constitutional Court delivering a ruling that declared a section of the South African Citizenship Act unconstitutional. The ruling means that South Africans who previously lost their citizenship due to acquiring dual nationality will now have their citizenship reinstated. The court found that Section 6, subsection 1 and paragraph A of the Citizenship Act, which automatically stripped South Africans of their citizenship when they took on a foreign nationality without prior approval, was unjustifiable and violated the Constitution. This ruling has significant implications for millions of South Africans, both at home and abroad, who were affected by this provision. So joining me now to take it forward, I'm joined by Craig Smith, who is an immigration lawyer at Craig Smith and Associates. Good afternoon, Craig. Thank you for your time. Section 6, subsection 1 and paragraph A of the South African Citizenship Act is the impound provision that was under the spotlight at the Constitutional Court. It's now been struck down with retrospective effect. You rarely ever see that, right? Where the retrospective application of a judgment is not limited. It's just from the day that it became law, it was unconstitutional, and therefore everyone it has ever affected has their rights restored. That speaks to the magnitude and the seriousness of the issue at hand.
Absolutely. The 1995 Citizenship Act was a consolidation of our citizenship laws. And in fact, the same provision is housed in our 1949 Citizenship Act, which is quite ironic because that's when the National Party in 1948 took control over government. So that provision has sat there for years. But effectively what the Constitutional Court did is any provision in any of our laws that is going to be declared unconstitutional has to be confirmed by a constitutional court. And this is precisely what the Constitutional Court did. They did not necessarily, this didn't go straight to the Constitutional Court. It went from the Supreme Court of Appeal, who overturned the High Court in Gauteng, and then they have now finally confirmed that's the impugned provision, Section 6(1)A of the Citizenship Act, is now unconstitutional. The key is that Section 20 of our Constitution, and I don't know if many people know, protects the rights of citizens not to be deprived of their citizenship. So now we had an opportunity where that constitutional provision was put up front against that Section 6(1)A, and hence the Supreme Court of Appeal and now the Constitutional Court have confirmed its unconstitutionality.
And the way I read the judgment, Craig, it appeared to me that the main issue that the Court grappled with was a lack of justification. What purpose? Because every law serves a purpose. Are you any wiser as to what purpose this automatic loss of South African citizenship upon acquiring the citizenship of another country, what purpose it served? I imagine that it was grounded in history in our country, but what was the overall justification?
Well, just remember, the Citizenship Act was promulgated in 1995. We're 30 years past that. People have moved, globalization, freedom, migration of people. The economy is intertwined, so families are intertwined, and obviously there's a whole change of circumstances from back then when they made the law to now. Now, the DA basically said that, look, what is the point of having to go to Home Affairs and seek the minister's approval whether you can take a second passport? What difference does that make? And effectively said that that is irrational. The department and government said, well, it's our right to do this. And if you want to do this, you can still go to the minister and ask for permission. Obviously, the DA trumped. Remember, they had Section 20, in their line of attack. And so the DA convinced the Supreme Court of Appeal, that there's no difference whether you go and apply for a retention or not. There's no difference whether that provision is there or not. Hence, it's irrational. And that was the position of the DA and, of course, Section 20. So there's no purpose in it, hence, but the government said there is a purpose. They lost.
Yeah, and it was all very interesting. Almost at times, it felt like splitting hairs. in terms of is this a deprivation of citizenship in a manner that is prohibited by Section 20, or is it mere regulation of the acquisition or loss of citizenship as provided for in Section 3 of the Constitution? But was it not telling that by the time we got to Constitutional Court, the Department of Home Affairs were basically saying that we will abide whatever decision, and basically made submissions, but we're not really opposing, but saying, whatever you decide, we will abide?
Oh, absolutely. The department were way on the back foot when it came to the Supreme Court of Appeals judgment and the confirmation hearing, which we've just had the outcome. They were never going to succeed on the basis that it's sort of government's prerogative to see this as a legitimate purpose, and they must oversee how the law is put in place. And there's a common sense argument to this, which the DA made, and they said, well, look, if you are, remember I said, lots have changed over the last 30 years, and you now go to the UK as a family, and you now take up naturalization in, hypothetically, let's say the UK, then you don't even know that you've got to act in accordance with 6.2 before you can do this. So many people, and this is not just, this is across the racial divide, because this is not just about white people, this is everybody who leaves South Africa and they spend time in a country, and then they don't even realize that they've lost their South African citizenship. And when they have children, if they do, those children won't acquire the right of citizenship, because you have to be parents have to be a citizen when you are abroad, if those kids can get citizenship. So it had a huge knock-on effect. This is the challenge for the department now to remedy this. Yeah,
I didn't hear, I don't think, maybe I missed it, Craig. I didn't hear your reasoning around what was the purpose? Why was this there in the books in the first place? Was it merely about loyalty of a citizen, that if you hold a South African passport and an Indian passport, you're probably going to have divided loyalties, you know, in the context of the 20th century, etc.? Because the way I understand it is that this was rooted in the law before the 1995 Act. Was that the reasoning, that loyalty more than anything else?
Well, it would be interesting if you were a fly on the wall and you had to try and listen to what the members of parliament were thinking of it. Remember, they make the law. What were they thinking in 1949? Because that same view has been retained up until now, 1995. What were they thinking? Was it a sovereignty? It's a loyalty to South Africa. If you leave, you're disloyal. But in the modern day, there's no disloyalty. You are not out of spite. You have no vengeance against South Africa if you leave for better greener pastures and then you come back. So the world has changed. The perception of having a second passport is not some evil thing. It is simply a logistical thing that follows you, and in the current trends of globalization, it's an absolute norm. Remember, they had an expert in there as part of the hearing, where he showed the trends, and over time, dual citizenship has just become more and more accepted across the world. Where people can have dual nationality. So this notion, you fight this notion of maybe loyalty stroke sovereignty versus, you know, the pragmatic, what's happening pragmatically in the world. And look, at the end of the day, you also have the Constitution that came in when they sat in 1949 and sat around a table and made this law. Section 20 of the Constitution was not there. So maybe the big thing here is a resounding victory for the Constitution and the Constitutional Court, and people can feel protected by our Constitution, the most supreme law in the land. And I think that's a good thing for Craig, every member of the country.
I want to fit this in very quickly. There are those who say that it would be folly to divorce the law from the politics behind it. So as the Constitutional Court said, that the declaration of constitutional invalidity of this has to do with the manner in which that this provision affected other rights that accrue specifically to citizens, such as the rights
Yes.
to the political rights. And in fact, I
Yes.
think for now, let me pause it there. But they mentioned the right to enter and remain in South Africa, freedom of trade, occupation and profession. But the political rights aspect is what I found interesting, because now,
Yes.
am I correct in reading it that there's a large constituency that has just opened up for any of these parties to this litigation, certainly the political party litigants, to pursue and convince them come election time?
Look, there's a school of thought that there may be 2 million people, it is a bit of a thumbsuck, abroad who have left South Africa for maybe the greener pastures, which may not be the only factor, but that is a factor. Now, what they were trying to say is if you deny that South African of citizenship, there are provisions in our constitution that are only applicable to citizens, which is the political right, the right to vote, the right to have a South African passport, freedom of trade, movement, etc. Whether the DA had a specific agenda, no one will know.
Yeah.
But at the end of the day, we've got to believe in our constitutional court. If we second guess our constitution, this would be foolish for our country and everyone who lives here. So I consider it rather a victory for the country. And as I say, there are also arguments. Remember, those people who were activists in the time of apartheid, they left the country in the 80s and 90s, or 70s, 80s, and 90s. The Citizenship Act also has a provision that those people who left the country before the 6th of October 1995 would not lose their citizenship. They would be exempt from losing it.
Yeah.
So that Citizenship Act takes all into account. And yes, whether you can divorce politics from any decision is not my task as a lawyer to talk upon, but it is there. You can raise questions, but at the end of the day, we need to be satisfied with our constitution and the decision making and the legitimacy of our constitution.
Craig,
and each citizen's rights.
Yeah, Craig, thank you. I've really enjoyed this conversation. That's Craig Smith from Craig Smith and Associates weighing in there about the outcome that came through from the Constitutional Court.